Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Whelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive in to Law Days and Lattes. Welcome back to Law Days and Lattes, where we talk about life, law, loss, and legacy, and how to navigate all of it with a little more clarity and a lot more confidence. I'm your host, Sidney Whelan, founder of the Whelan Law Firm, now serving North Central Missouri businesses and families in 3 convenient locations, Moberly, Carrollton, and now Paris. Today's conversation is one I'm especially excited about because it represents a shift, not just in how cases are resolved, but in how people experience conflict in the legal system. Recently, another attorney in our office and I completed the hours of mediation training required to become mediators. That means our firm is now certified to offer mediation services in both civil and family law matters. So today, I want to walk you through what mediation really is, how it works, when it's used, and why. More often than people realize, it can lead to better, more practical, and more lasting outcomes than traditional litigation. So in this first segment, I want to talk about what mediation really is. When people hear the word mediation, they sometimes think it's informal or optional, or maybe even less effective than going to court. But the truth is, mediation is a structured, recognized legal process. It can be voluntary, where both parties agree to sit down and try to resolve a dispute. Or it can be court-ordered, meaning a judge requires the party to attempt mediation before moving forward to trial. And that's important because even judges themselves recognize that many disputes are better resolved by the people involved rather than being imposed by the system. At its core, mediation is a facilitated negotiation. A neutral third party, called the mediator, guides the discussion, helps clarify issues, manages emotions, and keeps the process moving forward. But the key distinction is this. The mediator does not decide the outcome. The mediator does not issue any orders. And the mediator does not take sides. Instead, the parties themselves create the resolution. In this next segment, we'll talk about how mediation works, practically speaking. So let's talk about what actually happens in a mediation session, because understanding the process takes a lot of the mystery and anxiety out of it. Typically, the mediation begins with everyone together, either in person in a conference room or virtually, such as a Zoom meeting. The mediator sets the ground rules. This is a respectful, structured process. Everyone will have an opportunity to be heard. The goal is resolution, not necessarily winning. From there, the process often moves into private sessions called caucuses, where the mediator will break into separate sessions. Usually the parties will move into 2 separate conference rooms, if this is an in-person mediation. If it's by Zoom, the mediator will separate the parties into private Zoom rooms. This allows each party to speak openly with the mediator about their concerns, their goals, their fears about the outcome. The mediator then moves between the parties, carrying offers, asking questions, reality testing positions, and helping both sides move closer to common ground. It's not about forcing an agreement. It's about facilitating understanding and making progress. And when an agreement is reached, it can be formalized into a written document, which in many cases becomes enforceable just like a court order. So, mediation versus court. Who controls the outcome? This is where mediation really stands apart. In litigation, you're asking a judge to make decisions for you. And judges do important work, but they're limited. Often, they are limited in time, they have limited information in front of them, and often, they have a limited ability to craft creative solutions. So what happens? Well, you may end up with a court order that doesn't fully reflect your priorities. It may create logistical challenges or even force you into arrangements you never would have chosen on your own. Mediation changes that. Instead of being handed a decision, the parties build their own agreement. They can customize schedules, structure financial arrangements in more practical ways, address issues a court might not even consider. And in short, mediation allows for solutions that actually fit real life, not just legal standards. Segment 4, a better way to resolve disputes. One of the most important things to understand is this. Mediation is not about avoiding the law. It's about working within the law, while avoiding unnecessary conflict and court intervention. It creates a space where people can be heard, misunderstandings can often be cleared up, and solutions can be reached without escalating the dispute. And in many cases, that leads to faster resolution, lower costs, less emotional strain, and better long-term compliance with the agreement. Because when people have a hand in creating their own outcome, they're far more likely to follow it. When can mediation be used? Mediation can happen at different stages. Before a lawsuit is ever filed, or after litigation has started, and then again, it might be used right before trial when both sides are looking for a resolution. And again, it may be something the parties choose voluntarily or something the court requires as a part of the court process. But either way, the goal is the same: to give the parties an opportunity to resolve the disputes themselves, rather than having a decision imposed on them. Here are some real-world applications. Mediation is incredibly versatile. It works in divorce and custody cases, disputes over probate estates or inheritances, business disagreements, contract disputes, and even personal injury cases. And in each of these situations, there's often more at stake than just the legal issue. There are relationships, finances, reputations, and futures involved. Mediation gives people a way to address all of that, and not just what fits neatly into a legal claim. There's a human side of mediation. At the end of the day, mediation is more about resolution. It's about agency. Litigation can feel like something happening to you. Mediation invites you into the process. It allows you to speak directly to what matters most to you and explore your options and ultimately make decisions about your own future. That's a very different experience than sitting in a courtroom waiting for someone else to decide what happens next. When mediation might not be the best fit. Of course, mediation isn't the right tool for every situation. It often does not work in cases involving safety concerns or a significant imbalance of power, or an unwillingness to participate in good faith. That may require court intervention. But even in those cases, mediations can sometimes still play a role with the right structure and protections in place. If you're facing a legal dispute, I want you to remember this. You don't always have to choose the courtroom. There is another path, one where you have a voice, where you have input, and where the outcome is something you help create, not something that's imposed on you. Whether mediation is voluntary or court-ordered, it often offers an opportunity to resolve disputes in a more thoughtful, efficient, and often more effective way. And now, our firm is proud to offer mediation services to support that process for both individuals and attorneys seeking a neutral to help move cases toward resolution. Thank you for joining me today on Law Days and Lattes. If this episode made you think about your own situation, share it on your social media and with the other people in your life. It might be something they need to think about too. As always, take care of yourself, your family, and your future. Have a great week, my friends.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.